Here's what they don't tell you about surrogacy. While everyone shows you the happy ending with smiling parents holding their newborn baby, almost nobody talks about the legal nightmares that can completely destroy families, drain bank accounts, and leave children in legal limbo for years. And the worst part, most people don't even know these problems exist until it's too late. I'm not here to scare you away from surrogacy. I'm here to show you the reality that the industry often keeps hidden, because when you know what can go wrong, you can actually protect yourself and your future family. If you want to learn more about surrogacy, don't forget to subscribe to the channel and like the video. Surrogacy is supposed to be this beautiful arrangement where everyone wins. Intended parents get the baby they've always dreamed of, and surrogates get to help create families while being compensated for their incredible sacrifice. Sounds perfect, right? But behind that perfect picture, there's a legal minefield that catches thousands of people off guard every single year. We're talking about cases where parents can't take their own biological children home from the hospital. Situations where surrogates are forced to keep babies they never intended to raise. Families torn apart by international laws that nobody warned them about. And legal bills that stack up so high that people lose their homes trying to fight for their children. The problem is that surrogacy laws are a complete mess. And I mean that literally. There's no universal agreement on how surrogacy should work legally. Every country has different rules. Every state in America has different rules. Sometimes even different counties interpret the same laws differently. It's chaos. And this chaos creates real victims. Real families who did everything they thought was right, only to find themselves trapped in legal battles they never saw coming. So let's break down the actual legal challenges that happen in surrogacy. Not the sanitized version you hear from agencies trying to sell you their services. The real stuff that happens to real people. First, we need to understand that there are two main types of surrogacy, and the legal complications are completely different for each one. Traditional surrogacy is when the surrogate uses her own egg. That means she's genetically related to the baby. This creates a massive legal problem right from the start because in most places, the woman who gives birth is automatically considered the legal mother. Even if there was a contract, even if everyone agreed beforehand, even if she was paid, the law sees her as the mother. Now, gestational surrogacy is when the surrogate carries an embryo created from someone else's egg. She has no genetic connection to the baby. You'd think this would make everything simpler legally, right? Wrong. Because even though she's not genetically related, she's still the one giving birth. And in many legal systems, birth is what matters. This is where things get insane. You can have a situation where intended parents use their own egg and sperm to create an embryo. That baby is 100% genetically theirs. But when the surrogate gives birth, the law might say she's the legal mother anyway. The genetic parents have to go to court to get parental rights to their own biological child. Think about how backwards that is. You're genetically the parent, but legally you're nobody until a judge says otherwise. Let me give you a real example of how bad this can get. There was a case in the United States where intended parents went through gestational surrogacy using their own embryo. Everything seemed fine. The surrogate was on board. Contracts were signed. Money was paid. Then the surrogate changed her mind during pregnancy and decided she wanted to keep the baby. The intended parents took her to court. They had a contract. They had genetic proof. They had everything. But the court sided with the surrogate because the law in that state said the mother has rights that can't be signed away before birth. The intended parents lost custody of their genetic child. That's not even the worst part. They still had to pay all the surrogate's medical expenses and compensation because those were separate contractual obligations. So they paid over $100,000 and lost their baby. Cases like this happen because surrogacy laws are based on old adoption laws that were never designed for modern reproductive technology. When these laws were written, nobody imagined a world where you could separate genetics from pregnancy. The law assumed the woman giving birth was always the genetic mother. That's just not true anymore. But the legal system is slow to catch up with technology. So we're stuck with laws that don't match reality. Now let's talk about pre-birth orders and post-birth orders, because this is where a lot of people get completely blindsided. A pre-birth order is a court order issued before the baby is born that establishes who the legal parents are. When the baby is born, the intended parents' names go directly on the birth certificate. No questions asked. This is the dream scenario. But here's the catch. Only some states in America allow pre-birth orders. And even in states that allow them, there are strict requirements. Some states only allow them for married couples. Some require genetic connection. Some won't issue them if the surrogate is married. The rules are all over the place. If you can't get a pre-birth order, you're stuck with a post-birth order. That means when the baby is born, the surrogate is listed as the legal mother on the birth certificate. Then you have to go to court after birth and petition to have your names added and hers removed. This process can take weeks or months. During that time, you're in legal limbo. You might be able to take the baby home, or you might not. It depends on the state and the hospital. Some hospitals won't release a baby to anyone except the person listed on the birth certificate as the mother. That means the surrogate has to physically hand you your own baby like she's giving you permission. Imagine that moment. You've waited years for this, spent your life savings. This is your genetic child. But you have to wait for a woman you hired to decide when you can take your baby home because legally, she's the mother and you're nobody. And if something goes wrong between birth and when the court order is finalized, you have no rights. If the surrogate changes her mind or has a medical emergency or dies, your baby could end up in state custody while the courts figure out what to do. This actually happened. There was a case where a surrogate died shortly after giving birth due to complications. The intended parents weren't on the birth certificate yet because they were waiting for their post-birth order. The state took the baby into protective custody because there was no legal parent available. The intended parents had to fight in court to get their own child out of foster care. Let that sink in. Their child went into the foster system because of a paperwork timing issue. Now let's talk about what happens when surrogacy crosses state lines, because this is where things go from complicated to absolutely insane. Every state in America has different surrogacy laws. Some states are very surrogacy-friendly. Places like California, Connecticut, and Delaware have clear laws that protect intended parents and allow pre-birth orders. These are the states where most surrogacy happens. But other states are hostile to surrogacy. Michigan and Louisiana actually banned paid surrogacy completely. New York only legalized it recently and still has restrictions. Nebraska has laws that make surrogacy contracts unenforceable. So what happens if you live in Michigan but find a surrogate in California? Or if you live in California but your surrogate lives in Michigan? This is where legal jurisdiction becomes a nightmare. Which state's laws apply? The state where the intended parents live? The state where the surrogate lives? The state where the baby is born? The state where the contract was signed? The answer is it depends. And that uncertainty creates massive legal risk. Here's a real scenario that happens all the time. Intended parents in a surrogacy-friendly state hire a surrogate who lives in a different surrogacy-friendly state. Everything looks good. But then during pregnancy, the surrogate has to move to a different state for family reasons. Maybe her husband got a new job. Maybe she needs to care for a sick relative. Whatever the reason, she's now living in a state with different surrogacy laws. If the baby is born in this new state, the friendly laws everyone relied on might not apply anymore. The pre-birth order might not be valid. The contract might not be enforceable. Suddenly everything is in question. Or here's another common situation. Surrogate lives in a friendly state and gives birth there. Pre-birth order is issued. Parents take the baby home to their state, which is not surrogacy-friendly. When they go to get a birth certificate in their home state, that state refuses to recognize the pre-birth order from the other state. Now they need to go through a whole new legal process in their home state to establish parental rights. Some people have had to legally adopt their own genetic children because their home state wouldn't recognize the surrogacy arrangement from another state. The full faith and credit clause of the Constitution is supposed to prevent this. States are supposed to recognize legal judgments from other states. But some states argue that surrogacy orders are different and don't have to be recognized. So we get these legal battles between states, and families are caught in the middle. And if you think state to state is complicated, wait until you hear about international surrogacy. International surrogacy is where intended parents from one country use a surrogate in a different country. This used to be really common because surrogacy costs so much less in places like India, Thailand, Ukraine, and Mexico compared to the United States. But international surrogacy has created some of the most heartbreaking legal disasters in the entire surrogacy world. The biggest problem is citizenship. When a baby is born through surrogacy in another country, Which country is the baby a citizen of? The country where they were born? The country where the intended parents are from? The country of the egg donor, if that's different? The country of the sperm donor? Different countries have different citizenship laws. Some countries grant citizenship based on where you're born. Some grant it based on who your parents are. Some don't recognize surrogacy at all, which means they won't acknowledge the intended parents as the legal parents. This has led to situations where babies are literally stateless. No country will claim them as citizens because no country recognizes the intended parents as the legal parents. There was a famous case in Thailand where an Australian couple had twins through surrogacy. But Australian law at the time said they couldn't bring the babies home unless they could prove biological connection. The couple had used donor eggs and donor sperm, so neither of them was genetically related to the twins. Thailand wouldn't grant citizenship because the surrogate wasn't Thai. Australia wouldn't grant citizenship because there was no genetic connection. The babies were stuck in legal limbo for months. Or the case in India where a Japanese couple used a surrogate. The baby was born, but India wouldn't let the baby leave the country without proper documentation. Japan wouldn't grant citizenship without proof of Japanese parentage. The father was Japanese, but the mother was not, and Japanese law at the time required both parents to be Japanese for citizenship to pass to a child born abroad. That baby was stuck in India for months while lawyers fought it out. These kinds of situations happen because there's no international agreement on surrogacy. Every country just does whatever it wants. And when their laws conflict, real people suffer. It gets even worse when countries suddenly change their laws. This happened in Thailand in 2015. Thailand used to be one of the most popular destinations for international surrogacy because it was cheap and had good medical facilities. Then there were some scandals involving baby selling and surrogates being exploited. The Thai government freaked out and banned commercial surrogacy for foreigners almost overnight. But there were hundreds of surrogacy arrangements already in progress when this happened. Babies that were already conceived. Surrogates who were already pregnant. Intended parents who had paid deposits and were expecting their children. Suddenly, all these arrangements were illegal. Intended parents couldn't get birth certificates. They couldn't get travel documents. They couldn't take their babies home. Some people were stuck in Thailand for over a year trying to sort out the legal mess. Some had to abandon their babies because they couldn't afford to stay in Thailand fighting legal battles indefinitely. Similar situations happened in India, Nepal, and Cambodia when those countries suddenly restricted or banned international surrogacy. Families were blindsided. They thought they were doing everything legally, and then the laws changed underneath them. And it's not just about citizenship. It's about whether the home country will even recognize the child as legally yours. France, for example, doesn't recognize surrogacy at all. If French citizens go abroad for surrogacy, France considers it illegal and won't recognize the intended parents as the legal parents. There have been cases where French parents came home with babies from surrogacy abroad, and France refused to issue identity documents for the children. Without identity documents, these kids couldn't access health care, education, or any government services. Some French parents have fought for years in court just to get their country to acknowledge that their children exist. Germany has similar laws. Spain has similar laws. Several European countries have laws against surrogacy, even happening in other countries. They'll actually punish their own citizens for doing surrogacy abroad. So you could do everything legally according to the country where the surrogacy happened. Get all the right paperwork. Get a birth certificate with your names. Get the baby a passport. Come home. And then your own country says none of that matters and refuses to recognize you as the parents. Now let's talk about what happens when surrogates change their minds, because this is the scenario everyone fears most. Surrogacy contracts typically include a clause where the surrogate agrees to give up parental rights and hand over the baby to the intended parents. But here's the uncomfortable truth. In many places, these contracts aren't worth the paper they're printed on. Courts have repeatedly ruled that you can't sign away parental rights before a child is born. The logic is that you can't make a truly informed decision about giving up a baby until that baby actually exists. This is based on adoption law, where birth mothers are given a window of time after birth to change their minds. The problem is that surrogacy is an adoption. In adoption, the birth mother is the genetic mother and originally intended to keep the baby. In surrogacy, especially gestational surrogacy, The surrogate might have zero genetic connection and never intended to keep the baby. But the law treats them the same in many jurisdictions. So even with a contract, even with lawyers, even with everything done properly, a surrogate can change her mind. And when she does, the intended parents have to go to court and fight for custody, just like in any custody dispute. Now, to be fair, surrogates changing their minds is actually pretty rare. Most surrogates go through with the agreement. But rare doesn't mean never. And when it happens, it's devastating. There was a case in California where a surrogate was carrying twins for a Chinese couple. During pregnancy, doctors discovered one of the twins had a serious medical condition. The intended parents asked the surrogate to terminate that twin. The surrogate refused for religious reasons. The intended parents threatened to refuse both babies if she didn't terminate. The surrogate decided to keep both babies herself rather than give them to parents who wanted one of them dead. This turned into a massive legal battle. The intended parents argued they had a contract and genetic rights. The surrogate argued she had the right to refuse medical procedures and that the intended parents were unfit because they wanted to kill one of the babies. The case eventually settled, but it took months and cost everyone involved hundreds of thousands of dollars in legal fees. Or the case in New Jersey, which became known as the Baby M case. This was actually one of the most famous surrogacy cases ever. A couple hired a surrogate for traditional surrogacy, meaning she used her own egg. After the baby was born, the surrogate refused to give up the baby because she had bonded with her and wanted to keep her. The case went all the way to the New Jersey Supreme Court. The court ruled that the surrogacy contract was invalid and unenforceable. They said you can't pay someone to give up parental rights because that's essentially baby selling. The intended father got custody because he was the genetic father, but the surrogate was granted visitation rights as the legal mother. This case actually led to New Jersey banning paid surrogacy for years. It scared a lot of people away from surrogacy entirely. These cases show that contracts don't guarantee anything. If a surrogate changes her mind, you're going to court. And in court, anything can happen. Judges have a lot of discretion in family law. They're supposed to rule in the best interest of a child, but what that means is subjective. Some judges think children should be with their genetic parents. Some judges think children should be with the woman who gave birth. Some judges think children should go to whoever seems more financially stable or emotionally ready. You can't predict how a judge will rule, and the uncertainty is terrifying when your child's future is on the line. Now let's talk about what happens when things go wrong medically, because this creates even more legal complications. What if the baby is born with a disability or medical condition? What if the intended parents don't want a baby with that condition and refuse to take the baby? What if the surrogate doesn't want to keep a baby she never intended to raise? This has happened multiple times. There was a case where a surrogate was carrying a baby for intended parents, and prenatal testing showed the baby had Down syndrome. The intended parents told the surrogate they wanted her to terminate the pregnancy. The surrogate refused. The intended parents said if she wouldn't terminate, they wouldn't take the baby after birth. The surrogate gave birth to the baby, and the intended parents refused to take him. The surrogate didn't want to keep a baby she hadn't planned for. The baby ended up in state custody. Eventually, a family adopted him, but it took months to sort out. Who's responsible in a situation like this? The intended parents who contracted for the pregnancy but refused the baby? The surrogate who carried the baby but never wanted to be a mother? The doctors, who maybe should have provided better counseling? The lawyers who wrote the contract? Most surrogacy contracts try to address this by including clauses about what happens if the baby has medical issues. But these clauses are often vague or unenforceable. You can't force someone to take a baby they don't want. You also can't force a surrogate to have an abortion. Or what if something goes wrong with the surrogate's health during pregnancy? What if she needs an emergency C-section? What if she needs to be put on bed rest and can't work? What if she has permanent medical complications? Surrogacy contracts typically include insurance and medical coverage. But what if the medical costs exceed what's covered? What if the surrogate has long-term disability from the pregnancy? Who pays for that? There have been cases where surrogates were left with massive medical debt because complications weren't covered by insurance or the intended parents refused to pay. Some surrogates have sued intended parents for medical costs. Some have won, some have lost. It depends on the contract and the state. Or what if the surrogate dies during pregnancy or childbirth? This is rare, but maternal mortality is a real risk. What happens to the baby? What happens to the surrogate's family? Who's liable? Some surrogacy contracts include life insurance policies for the surrogate, but not all do. And even with life insurance, there are questions about whether the intended parents could be held legally responsible for the surrogate's death. There was a case where a surrogate died from complications shortly after giving birth. Her family sued the intended parents and the agency, claiming they didn't properly screen her medical risks and pressured her into the pregnancy despite health concerns. The case settled out of court, so we don't know what the outcome would have been, but it shows the legal exposure everyone faces. Now let's talk about the financial side of legal challenges, because even when surrogacy goes smoothly, the legal costs are staggering. A typical surrogacy arrangement in the United States costs between $100,000 and $200,000. A huge chunk of that is legal fees. You need lawyers to draft contracts. You need lawyers to get pre-birth or post-birth orders. You need lawyers to navigate the different state laws. You need lawyers to fix problems if they come up. And if something goes seriously wrong and you end up in a custody dispute, legal fees can easily add another $50,000 to $100,000. Some people have spent over $300,000 total on surrogacy once all the legal battles were included. Most people don't have that kind of money. They take out loans. They drain retirement accounts. They sell their houses. And if the surrogacy falls through or they lose custody, they're left with crushing debt and no baby. Insurance doesn't help much because most insurance companies don't cover surrogacy-related legal costs. Some intended parents buy specialized surrogacy insurance, but these policies are expensive and often have exclusions for legal disputes. And here's something most people don't realize. Even if everything goes perfectly, you're probably going to need lawyers in multiple states. If you live in one state and the surrogate lives in another and the baby is born in a third state, you might need lawyers licensed in all 3 states. Each lawyer charges separately. Plus, if you're doing international surrogacy, you need lawyers in both countries. You need immigration lawyers. You need citizenship lawyers. You need someone who understands international family law. The costs multiply fast. Some people try to save money by using agency-provided contracts instead of hiring their own lawyer. This is a huge mistake. Agency contracts are written to protect the agency, not you. You need your own lawyer reviewing everything and representing your interests. But hiring good lawyers is expensive, and there's no guarantee that spending more money gets you better results. You can have the best lawyer in the world and still lose if you're in a state with bad surrogacy laws or in front of a judge who's biased against surrogacy. The financial risk is massive, and most people going into surrogacy don't fully understand just how much money they might need if things go wrong. Let's talk about same-sex couples, because they face extra legal challenges that opposite-sex couples don't. For male couples using a surrogate, the legal process can be complicated even in friendly states. Usually one of the men is the genetic father, but the other man has no genetic or gestational connection to the baby. Some states won't put both men on the birth certificate through a pre-birth order. They'll only put the genetic father. That means the non-genetic father has to do a second-parent adoption after birth. This is an extra legal process with extra costs and extra time. And in some states, second-parent adoption for same-sex couples is difficult or impossible. There have been cases where same-sex couples did surrogacy, and then when they tried to get both names on the birth certificate, the state refused based on religious or conservative policies. They had to sue the state for discrimination. Some won, some lost, some are still fighting. For female couples using a surrogate, the legal issues are different but still complicated. If one woman provides the egg and the other is listed as an intended parent, most states will recognize both as parents. But some states won't put both women on the birth certificate without the second-parent adoption process. And if female couples do reciprocal IVF, where one provides the egg and the other carries the baby, they're usually fine legally. But if they use a surrogate, some states get confused about whether the woman who provided the egg or the woman who is the non-genetic intended parent is the legal mother. The law is still catching up to modern family structures. Many surrogacy laws were written assuming a heterosexual couple and don't clearly address same-sex couples. This creates ambiguity that leads to legal fights. Plus, Same-sex couples doing international surrogacy face even more challenges because many countries don't recognize same-sex parents. There have been cases where male couples did surrogacy abroad, and the country wouldn't issue a birth certificate listing both fathers. Or where female couples were told only one woman could be the legal mother. Some countries will only recognize opposite-sex married couples as eligible for surrogacy. If same-sex couples try to do surrogacy in those countries, the whole arrangement is illegal from the start. Now let's talk about what happens when intended parents split up, because relationships don't always last through the surrogacy process. Surrogacy typically takes at least a year from start to finish, sometimes longer. During that time, intended parents might break up, get divorced, or have major life changes. What happens to the surrogacy arrangement? If the intended parents are married and get divorced before the baby is born, the situation is messy. Some states say the baby belongs to both parents, just like a baby born during marriage. Other states say the baby only belongs to whoever is genetically related. If both intended parents are genetic parents, they usually both get parental rights, and then have to work out custody like any divorced couple. But what if only one is genetically related? What if they use donor eggs or donor sperm? There was a case where a married couple started surrogacy using the husband's sperm and a donor egg. Before the baby was born, the couple divorced. The wife decided she didn't want the baby anymore because she wasn't genetically related and was leaving the marriage. The husband wanted the baby. The surrogate wanted nothing to do with the dispute. The court ruled the baby belonged to the husband because he was the genetic father and the only one who wanted parental rights. The wife had no legal obligation. But what if the wife had been the genetic parent and the husband was not? Would the result be the same? The law isn't clear on this. Different states would rule differently. It gets even more complicated if the intended parents aren't married. Some states don't allow unmarried couples to do surrogacy at all. Others allow it but don't have clear laws about what happens if the couple splits. If unmarried intended parents break up and both are genetic parents, do they both get rights? What if only one is genetic? What if neither is genetic and they use donor egg and sperm? There was a case where an unmarried couple did surrogacy with donor egg and donor sperm. Neither was genetically related to the baby. They broke up before birth. Both claimed they wanted the baby. The court had to decide custody between two people who had zero genetic connection to the child. The judge ruled based on who was more financially stable and emotionally ready, but basically admitted there was no good legal framework for this situation. And here's a nightmare scenario. What if intended parents split up and neither one wants the baby anymore? Can they just walk away? Is the surrogate stuck with a baby she never wanted? This has happened. There was a case where intended parents used donor egg and donor sperm for surrogacy. They broke up during the pregnancy, and both said they didn't want the baby. The surrogate definitely didn't want to keep a baby she had no genetic connection to and never intended to raise. The baby ended up in foster care. Who's legally responsible in that situation? The intended parents who contracted for the baby, the donors who provided genetic material, the surrogate who gave birth. Everyone involved hired lawyers and blamed everyone else. It was a disaster. Let's talk about embryo disputes because these create legal issues even before pregnancy starts. In surrogacy, especially gestational surrogacy, embryos are usually created in advance and frozen. Then one or more embryos are transferred to the surrogate. But what if there are leftover embryos? Who owns them? Usually the intended parents own the embryos. But if the intended parents divorce or die or change their minds, what happens? Can one parent use the embryos without the other's consent? Can embryos be divided in a divorce like property? Courts have struggled with this. Some courts say embryos are people and have rights. Other courts say embryos are property. The legal classification matters because it affects who gets to make decisions about them. There was a famous case where a couple created embryos for surrogacy and then divorced. The woman wanted to use the embryos to have a child with a surrogate. The man didn't want her to because he didn't want to be a father to children from his failed marriage. The case went to court. The judge ruled that the man's right not to be forced into parenthood outweighed the woman's desire to use the embryos. She lost. But in a different case in a different state, the court ruled the opposite way. The woman was allowed to use the embryos over the man's objection because she argued it was her only chance to have a genetic child. There's no consistency. Every case is different. And if embryos are being stored for potential surrogacy, the disputes get even more complicated because the surrogate is also involved. Does she have any say? Can she refuse to carry an embryo if the intended parents are fighting? Or what if intended parents die and leave frozen embryos behind? Can their families use those embryos with a surrogate? Can the embryos be inherited? There was a case where a man died and his parents wanted to use his frozen sperm to create embryos and hire a surrogate so they could have a grandchild. The man's widow objected. She said her husband never consented to having children after death. The court sided with the widow. But in another case, a woman who died of cancer had frozen her eggs before chemotherapy. Her parents wanted to create embryos and use a surrogate. The woman had left written instructions saying she wanted her parents to do this. The court allowed it. Again, no consistency. Every case is decided based on the specific facts and the judge's interpretation. This uncertainty makes it hard to plan or know what your rights are. Now let's talk about fraud and exploitation, because the surrogacy industry has serious problems with people being taken advantage of. Some surrogacy agencies are legitimate and ethical, but others are basically scams. They take huge fees from intended parents and pay surrogates almost nothing. They lie about success rates. They don't properly screen surrogates or intended parents. They disappear when problems happen. There have been cases where intended parents paid an agency $100,000, and the agency took most of it and left the surrogate with barely $20,000. The surrogate felt exploited, and the intended parents felt ripped off because they thought the surrogate was being properly compensated. Or cases where agencies promised they had surrogates ready to go, but actually had no one. Intended parents paid deposits and waited months for a match that never happened. When they asked for refunds, the agency said the money was non-refundable. Some agencies operate in legal gray areas. They're based in states with unclear surrogacy laws, so if something goes wrong, it's hard to sue them. They might not have proper licenses or insurance. If they go out of business, your money is gone and you have no recourse. There's also the issue of international agencies that facilitate surrogacy in developing countries. Some of these agencies are basically running baby factories. They recruit poor women who are desperate for money and don't fully understand what they're agreeing to. The women are housed in group facilities and monitored constantly. They're essentially treated like incubators. This has led to accusations of human trafficking and exploitation. Several countries have shut down these operations, but they pop up somewhere else. Intended parents often have no idea this is happening. They think they're working with a legitimate agency and only later find out the surrogate was exploited. When this comes to light, it creates legal problems for the intended parents. Some have been accused of participating in human trafficking. Some have had their children taken away because the surrogacy was ruled illegal. Even if they didn't know what was happening, they can still face legal consequences. There's also fraud by individual surrogates. Some women pretend to be pregnant or lie about their medical history to get the compensation money. By the time the intended parents find out, the money is gone. There was a case where a woman claimed to be pregnant through surrogacy for multiple couples at the same time. She collected deposits and medical expense money from all of them. She wasn't actually pregnant at all. It was a scam. She got arrested, but the families lost their money. Or cases where surrogates hide serious medical or psychological issues. Maybe they have a drug problem. Maybe they have a history of mental illness that would disqualify them. They lie on the screening forms because they want the money. Then during pregnancy, the issues surface, and the pregnancy has to be terminated or the baby has problems. Can the intended parents sue for fraud? Sometimes yes, sometimes no. It depends on what can be proven and what the contract says. But even if you can sue, you might not recover your money if the surrogate doesn't have any. The surrogacy industry needs more regulation to prevent this stuff. But regulation is hard because there's no federal oversight. Each state does its own thing. And internationally, there's almost no enforcement at all. Let's talk about the impact on children, because all these legal battles affect real kids who didn't ask to be born into complicated situations. When a child's parentage is disputed, that child lives in uncertainty. They might not have a legal name. They might not have citizenship. They might not be able to access education or health care. They might be shuffled between families or put in foster care while courts figure things out. This is traumatic. These kids grow up knowing they were fought over in court. They know they were born through surrogacy, which already makes them different. They might have identity issues trying to figure out who their real parents are. Some kids born through surrogacy have sued when they got older. There are cases where children born through traditional surrogacy track down their genetic mothers, the surrogates, and try to establish relationships. This created legal questions about whether the surrogate had any parental rights or obligations. There are also ethical questions about whether it's fair to create children through arrangements that are legally uncertain. If there's a good chance the intended parents won't be able to get legal custody, should they be creating that child at all? Who advocates for the child's interests in these situations? Courts are supposed to rule in the best interest of a child, but what does that mean when the child is stuck between a surrogate who doesn't want them and intended parents who might not be able to take them? Or when the child has medical needs that nobody wants to pay for? These kids deserve stability and clarity about who their parents are. But the legal mess of surrogacy often denies them that. So with all these legal challenges, what can people actually do to protect themselves? First, do your research. Understand the laws in your state, the surrogate state, and any state where the baby might be born. Don't assume everything will be fine just because an agency says so. Get independent legal advice from a lawyer who specializes in reproductive law. Second, hire your own lawyer. Don't rely on agency contracts or agency lawyers. You need someone representing your interests specifically. Make sure your lawyer has experience with surrogacy cases and knows the laws in all relevant jurisdictions. Third, get everything in writing. Contracts should be detailed and cover every possible scenario. What happens if the surrogate changes her mind? What happens if the baby has medical issues? What happens if you die or get divorced? What happens if laws change? The more specific the contract, the better. Fourth, make sure everyone is properly screened. Surrogates should have medical, psychological, and background screenings. Intended parents should too. Agencies should be thoroughly vetted. Check references. Look for complaints or lawsuits. Don't work with anyone who seems shady. Fifth, plan for the worst-case scenario financially. Assume everything will go wrong and double your budget. Have money set aside for legal battles, medical complications, and unexpected delays. If you can't afford the worst case, you might not be able to afford surrogacy. Sixth, consider working only in surrogacy-friendly states. If you live in a state with bad surrogacy laws, it might be worth having the surrogate live and give birth in a different state. Yes, this adds complexity, but it reduces legal risk. Seventh, avoid international surrogacy unless you fully understand the legal risks and have expert legal help. The money you save is not worth the potential nightmare of trying to bring your baby home. Eighth, keep detailed records of everything. Every conversation, every payment, every medical appointment. If something goes wrong, you'll need this documentation in court.